Okay, thank you for joining me here. I just learned that Julie from Korea is online. And so as long as she is online, I will take advantage of that moment because connection can be lost at any moment. I will leave the opportunity to Julie to introduce herself. She represents FKMP, which is the South Korean CMO for performing artists, musicians. And in that capacity, she has been involved in some policy work, but also with the collection side of things. I'm very glad, hi Julie, I'm very glad to have Julie on board because during the preparatory meetings that we had, I found out a little bit to my surprise that in South Korean legislation, since 2004, there is an exclusive right that has been granted to performing artists for their work on streaming. But I see that now Marcos, is also available. So I'm going to turn to Julie. Julie, you have now the floor. Could you please explain to us a little bit more about this very specific exclusive right that you have in South Korea, and what has been the impact on your activities as a collective management organization? Because I can assume having an exclusive right is wonderful, but it's not always so obvious than to conduct negotiations, for instance. So could you provide us with some insight on this South Korean right, please?
Okay, hi guys. I'm Julie Lee from FKMP South Korea, and I've been with FKMP since 2017. So like Christophe said, that's right. When it comes to streaming services, the exclusive right of interactive transmission for performers was introduced into the Korean Copyright Act in 2004. But actually, even before that, this right had already been exercised in practice under the reproduction right in Korea. And since it's recognized in the WPPT, I thought it might be more helpful today to share how this right has actually been exercised in Korea, rather than focusing on how it was legally introduced. Let me give you a little background on the Korean music market by the time the interactive transmission right was introduced. Well, it had a number of challenges. There were income gaps between record producers and performers, problems with unfair exclusive contracts, especially surrounding the K-pop idol production model, financial struggles for artists, and buyout contracts that stripped session musicians of their ongoing rights. These challenges sparked discussions on the need to introduce a performer rights system. So, in a way, the interactive transmission right started as something more than just a legal concept. It had the character of a social security measure, almost like an artist pension or a culture fund designed to support the sustainability of artistic activities. Perhaps this reflects something unique about Korea, but as for featured performers with exclusive contracts, there are many cases where they are not fully protected after the termination of their contracts. However, with this interactive transmission right, featured artists are able to receive separate royalties for their performances, even while they are still bound by exclusive contracts. For non-featured performers as well, the system ensures that they receive not only a one-time session fee, but also ongoing royalties based on the usage or sales of the recording after release. This helps provide a stable income, motivates continued artistic activities, and strengthens their sense of pride as professionals.
Thank you for your contribution. I think I'm moving to South Korea. Food is nice, people are nice, and they have excellent legislation there. Please stay a little bit more online. We will revert back to you when we will discuss collective management in times of streaming. But I will hand now the floor to Marcos. who is with us from Brazil, who unfortunately couldn't make it due to parliamentary proceedings. And the way that I introduced you earlier on, Marcos, was via the international activities via WIPO and how that was impacting your work also as a legislator in Brazil. I've heard that there are a number of very interesting developments going on right now in Brazil in terms of legislation. You're the only policy maker also on the panel, so very curious to find out how Brazil has been dealing with streaming. You have the floor.
Gracias por estar aqui. Me gostaria, estou compartilhando uma pantalla, não sei se está disponível, pero se não está, vou dizer que há na pantalla. Vou começar minha apresentação falando de la proposta que GRULAC, el grupo de los países de Latinoamérica y Caribe, presentaron en OMPI, en su Comité Permanente de Derechos de Autor y Derechos Conexos, SCCR, en 2015. En aquel momento, en 2015, el GRULAC apresentou uma proposta de plano de trabalho que proponia o análise e a discussão del quadro legal usado para proteger as obras em los serviços digitais. E algumas coisas que nesse documento buscávamos discutir seria, por exemplo, o uso de bot farms, de hacienda de clics para impulsionar ou fazer uma distorção de las ejecuções, a relação entre el payola y las playlists, porque en el digital nosotros tenemos una impresión de que el playlist es el nuevo payola. También proponíamos una discusión sobre prácticas corporativas, especialmente sobre a transparência e a distribuição de los pagos, e também buscávamos consenso sobre uma remuneração justa para todos os titulares, incluindo os intérpretes e os músicos. E desde 2015, este ponto de copyright in the digital environment foi incluído em la agenda del SCCR, pero bajo la rúbrica de other issues, other matters, outros assuntos. Después de la presentación de ese primer paper, entre 2016 y 2019, la OMPI presentó una serie de estudios, muchos estudios sobre todas las regiones, las legislaciones existentes. Hubo una serie de eventos, seminarios, pero siempre apenas con visiones generales sin direccionar una propuesta a respecto de las inquietaciones que GRULAC presentó. Durante la pandemia no hubo más reuniones del comité, y cuando las reuniones regresaron en 2023, nosotros, el GRULAC, de nuevo, presentó un paper llamado Copyrighting Digital Environment as a Standing Agenda Item, donde proponíamos también un esquema de remuneración compensatoria, equitativa, para los titulares de derechos conexos en los servicios de streaming. Y desde 2024, nosotros, las delegaciones de GRULAC, pero sobre todo Brasil, reiteradamente tenemos solicitado la inclusión del tema de Copywriting Digital Environment como un ítem permanente de la agenda. Porque entendemos que el SCCR es el foro apropiado para ese tipo de discusión. También tuvimos bajo ese punto de la agenda en Other Issues sobre el digital, la realización de 2 sesiones sobre inteligencia artificial, 2 sesiones informativas. Y en la última, en la reunión 45 del SCCR, hicimos nuevas propuestas sobre estudios y acciones concretas, como las relaciones entre creadores, artistas y los proveedores globales, las cuestiones involucradas con la inteligencia artificial, incluyendo las prácticas de mercado y las implicaciones sobre los derechos de autor y derechos conexos, la remuneración justa para artistas y creadores en entorno digital y un posible quadro internacional para una remuneración equitativa para esses titulares y su recaudamiento y distribución. Y basado en los comentarios que recibimos en la última sesión del comité, nosotros vamos a presentar en diciembre una versión revisada del documento 45.4. Básicamente, los argumentos que GRULAC ha apresentado es que los tratados de Internet de OMPI, el WCT y WPPT, son parte del problema. Esses tratados foram criados em um tempo onde a internet aún estava em seus estágios iniciais e onde a internet que as pessoas usavam era uma internet discada, não havia banda ancha, não havia uma série de empresas que hoje caracterizam o entorno digital, siquiera había ocorrido todos los problemas de la piratería derivada del surgimiento de Napster. Google no existía. En fin, eran otros tiempos, existía el entorno digital, pero era un entorno digital bastante diferente del que hay hoy, caracterizado por el streaming y por ahora la inteligencia artificial. Pero más allá de OMPI, Brasil procuró también llevar esa discusión en el G20 y en el BRICS, donde nosotros asumimos la presidencia recientemente, hubimos suceso en incorporar en las declaraciones de G20 y BRICS la importancia de pagos apropiados y de regulación de derechos de autor y conexos y de transparencia en esos servicios, y también en UNESCO, en el Mondiacult que ocurrió en el último mes en Barcelona, en España. Nosotros también tuvimos un trabajo de acrescentar, de incluir esa discusión en la declaración final, y curiosamente fue más fácil hacer ese trabajo en G20 y BRICS que en UNESCO, y nosotros creíamos que sería más fácil en UNESCO. Un otro argumento que presentamos para la cuestión del comité es que la división de tiempo entre los temas permanentes hace muy difícil hacer un debate sobre el entorno digital y los derechos de autor y derechos conexos. Quase toda la agenda está ocupada por dos temas que todavía no tienen una perspectiva de avance. Por ejemplo, aquí está la división actual del tiempo del comité. Hoy 60% va para la discusión de la protección de los organismos de radiodifusión, que es un tema que está siendo discutido hace 28 o 29 años. Y todavía aún estamos distantes de una resolución, porque incluso no hace más sentido algunas discusiones que teníamos hace 2 décadas. Más 30% están dedicados al tema de las limitaciones y excepciones, que aunque nosotros tengamos también preocupaciones y creemos que es importante la discusión, la realidad es que en la forma como las cosas son discutidas, buscando un gran tratado de limitaciones y excepciones, eso no va a ocurrir nunca. Y además, sobra apenas 10% del tiempo de las reuniones de comité para se discutir los otros asuntos, other matters, other issues, y en other issues no hay solo el punto del entorno digital. Hay también esos 10%, tenemos que dividir con derechos de reventa, que es un otro punto, los derechos de los directores de teatro, ahora también discusiones y estudios sobre los derechos de los autores y intérpretes de las obras audiovisuales. En fin, es imposible se profundizar cualquier discusión sobre el tema del entorno digital actualmente en el comité por esa división de tiempo. Entonces, caminando para una conclusión, nosotros tenemos buscado hace 10 años un debate constructivo que busque soluciones para el problema de los titulares de derechos de autor y conexos en el entorno digital. Nosotros tenemos avisado todo el tiempo que ese debate debe ocurrir luego, porque los cambios son muy rápidos. y incluso yo ya me manifesté más de una vez en el plenario diciendo que el SCCR debe dejar de ser un foro donde el tiempo se cuenta en eras geológicas, porque es lo que ocurre hoy y va a ser demasiado tarde si esperarmos 28 años para efectivamente trabajar en el entorno digital. Nosotros defendemos que sea el punto permanente y principal de la agenda del comité. Si nada es hecho, continúan las injusticias y todos los problemas que ya fueron dichos por Christophe y que creo que los otros colegas de mesa van a hablar. Y continuamos solicitando una modernización de los tratados de Internet de hombre. Y para no dejar de hablar de Brasil, nosotros nos cansamos, señores, nos cansamos. Hace 10 años estamos tentando una discusión global porque entendemos que los problemas son globales. Y ustedes saben que los grandes opositores de una discusión son los países del Grupo B y con eso no se avanza. Y nosotros estamos trabajando internamente con 2 proyectos de ley, a respecto de los servicios de streaming y el otro sobre inteligencia artificial, que voy a hablar sobre él en la sesión del día 24. Bueno, sobre el proyecto de ley de servicios de streaming que estamos discutiendo en nuestro Senado, básicamente las disposiciones principales son una remuneración compensatoria para todos los titulares de obras musicales y audiovisuales, incluyendo performance en músicos, independiente de haber o no contratos de cesión sobre sus derechos, y esa remuneración compensatoria tiene el carácter inalienable y irrevocable. También el proyecto hace una regulación de la cuestión de las playlists y de las haciendas de bots. También se garante una remuneración para los titulares de derechos conexos, incluyendo en los servicios de streaming de vídeo. Y la grande novedad es que nosotros creamos una posibilidad, o mejor, una obligación de que los proveedores puedan deducir del pago que hacen a los productores de fonograma el pago que harán para performers y músicos. Y hay una serie de mecanismos que nosotros imponemos a los productores de fonogramas para que hagan esa deducción, incluso con multas, con caracterización de abuso de derechos de propiedad intelectual, con implicaciones con las autoridades de defensa de competencia. La otra cosa es que una de las orígenes del problema que hay con los músicos son los global deals hechos entre los productores de fonograma, las majors, y las plataformas de streaming, y nosotros creamos mecanismos para que esos global views se submetan a nuestra legislación. También prohibimos la remuneración de contenido generado por inteligencia artificial de una forma que eso no crie más personas, empresas titulares que van a recibir las recetas destinadas a pagar al pago de derechos de autor y derechos conexos. Y por fin, yo pido que comprendan, nosotros nos cansamos, tentamos una solución global, y como eso hay una resistencia muy grande de los países del grupo B, de los países desarrollados, la forma que buscamos no es trato nacional para los titulares extranjeros, sino con base en la reciprocidad formal, porque se trata de un derecho residual, que es como nosotros estamos tratando ese tema. Gracias, disculpe por el tiempo.
Thank you very much, Marcos. What I find fascinating in the Brazilian approach is that you have a multi-pronged attack. You're not just working on the level of WIPO, you also try to make your point heard on the level of the G20, on the level of UNESCO. So that's a very important one. With regard to the SCCR, we learned only this morning that Indonesia will introduce also a position paper, am I using the right term here, that is also more or less in support of what Brazil has been proposing. So I think for us as delegates of CMOs, of unions, of special interest groups, that we also need to contact our local copyright neighboring rights offices, our local administrations, because they're the ones who are represented at the level of WIPO. They are the ones who are weighing in on the decision making. And you're quite right in the fact that you say that you're somewhat disappointed in the developed countries. We've had the same experience with audiovisual, where, for instance, the Beijing Treaty has been ratified by a whole host of countries outside the European Union, but within the European Union, we can't seem to get any further. And there's one last aspect, and that I would also like to throw into the panel and into the group. We've had numerous conferences, we've had numerous analysis, white papers, green papers, whatever papers, about this problem, which is quite fairly a global problem, because the people or the companies that are using the repertoire of our artists are organized on a global level, will always try to seek out the weakest link in the chain. And so it's been a very slow process. You've talked about 20, 30 years. Meantime, what we have seen growing all over the world is a very viable, profitable industry, which has been created on the basis of huge catalogs of our repertoire. And it's the same story we see coming back time and time again, not only with regard to streaming, but also with regard to AI. There's whole collections of repertoire that are being used to provide a profit. So the image I always use is, let's suppose that you went out of here, go into the nearby supermarket, start emptying the shelves, and then you pass towards the exit. Of course, the lady or the gentleman at the cash register will say, oh, wait, you can't do that, you have to pay. And you would go like, no, wait, you don't understand. This is disruptive shopping. As soon as I've learned how I can make $1 out of this, I will pay you something. So it's the same reasoning behind this. And that's something that I would like to throw to the members of the panel. Do you agree with the fact that the time for analysis, conferences, etc. is over, that there should be a definitive solution that compensates people who are actually making the repertoire, or is the current situation satisfactory or not? Who wants to take the floor? Tino?
Do you want the long answer or the short one?
We still have about 55 minutes, and there are other people who would like to intervene.
I think you're absolutely right. There's a systemic inequitability, is that a word? That's going on right now with the way musicians are being compensated. And the people that we're hearing from that are complaining about it the most, at least in the North American market, are the musicians, are the performers. The side musician issue is a big issue. It's a real big issue. It's like the unsung heroes. And your grocery store analogy was quite good. I kind of look at it as, having to put a sign on your front door that says, "Do not steal from my house." In other words, it should be an obvious thing that we're dealing with right now. So I want to, if I may, sure. I want to break things down a little bit, because I like that we're talking about WPPT. As you know, the United States is not a party to the Rome Convention, but we do rely on WIPO and the WPPT. It was 1996, right, I think? Yeah. So that provides for the equitable remuneration only for broadcasting and communication to the public, meaning bars and restaurants, of course. The right of making available at a time and place of the listener's choosing is housed under the umbrella of exclusive rights. Since we cannot effectively monetize streaming as an exclusive right, it would be to the performer's benefit to have a right of equitable remuneration. The AFM has negotiated streaming payments, both in the motion picture industry and the television industry. And some minor changes to the sound recording agreement, which is coming up this year, is also going to be necessary. But the real profit is being reaped by big tech. To some extent, even the producers are intimidated and lack leverage. A statutory equitable remuneration would help, well, it would help the United States. It would help the United States and Canada. I'm speaking for North America right now. This is another thing. I think this was mentioned earlier. These private contracts, we should have a minimal standard for those contracts that these performers are signing into, so that we can get all the boats to rise in the tide. It's really important. I want to defer to our friend from Brazil here. Grulak proposed, and the AFM supported, I think you know that, putting the streaming issue on the permanent agenda of the WIPO Standing Committee in Copyright and Related Rights. This would be the first step of many in a very long trajectory toward a diplomatic convention addressing streaming inequities, but at least it would be a step. Unfortunately, the proposal was not successful, but I urge FEM members to continue to work hard to seek streaming as a permanent agenda item. You talk about, we seem to have this conversation a lot. I've been to several online conferences with this organization, and it's almost like we're rehashing a lot of the stuff that we keep saying, and nothing has changed. I feel like sometimes when I come to these things, I'm a hamster on a hamster wheel. You know what a hamster wheel is? You know the thing that they run on? So they're working really hard, but they're not really getting anywhere. This is a problem, folks. The time for action is now. I truly believe that. Some of the things I talked about the last time I was at a conference was the idea, because we are talking about streaming here. We're talking about the idea of legislation and collective bargaining. As a trade unionist, the collective bargaining part is front and center for me, but of course we have to be active in the legislative arena. In the United States, Congress needs to pass the Protect Working Musicians Act. This would help change, again, the systemic inequities in streaming. So long as the United States government does not pay performers for terrestrial broadcast plays, we will remain at a disadvantage in negotiating with the streaming platforms. This is a real problem for us. And I would urge that we continue to work hard, but let's get off that damn wheel and get somewhere.
Thank you, Tino. Couldn't agree more. I think we've been living Groundhog Day for quite a while now, so that's true. So we're counting a lot on international initiatives, and again, lots of respect for what Brazil, Indonesia, and other countries are doing on the level of WIPO, and they certainly merit our support. Now, turning from, let's say, policy to someone who has been studying policy for his entire academic career, we have Paul Tormans on the panel, who is Professor of Intellectual Property Right at the University of Nottingham, and who has been educating students about copyright and neighboring rights since 30 years odd. What is your take on the European legislation or regulation that was created with the CDSM directive? Because the UK left, there's no causal link there, but the UK left the European Union just a couple of years prior to the expiration of the delay to transpose the directive. And I'm very curious to find out if or not the UK adopted parts of what was stipulated in this European directive, or did it go into an entirely different direction? I don't think you adopted an exclusive right, otherwise I would have learned from it much earlier. We've already mentioned the negotiations of the musicians' union with the record producers to obtain a collective bargaining agreement, because I think they made the same evaluation as we have already done here. It's going too slow, and if we're not getting a proper answer from our legislative bodies, we need to revert to another solution. So could you provide us with some insight on what is happening in the UK right now?
Well, thank you, Christophe. Maybe, ladies and gentlemen, I should say, as a disclaimer, I'm not a UK citizen, right? So if you want to blame it from the UK side on the foreigner, some of my students tend to say in feedback, go home, blooming foreigner, or something like that, you know, feel free. Having said that, this is quite a remarkable story, because if you look back at the European directive when it was negotiated, Brexit was in the making. Right? We had a government in the UK that wanted to leave, was working towards a solution to leave. But eventually, when you look at the directive, in the end, they were rather happy with it. There are lots of policy documents that say, this is the kind of compromise that we want. Now, they wouldn't implement it, because we left. But they were going to do something very similar, i.e. retake control, and then do exactly the same, but put a different stamp on it. Now, what we've learned since, maybe that says something about politicians, maybe that says something about how we should not approach this topic, very little has happened. We're at the standstill. I fully understand and I agree that the European directive and the way it is being implemented is not the Valhalla. You know, we are not there. But something's happening. Some attempts are being made. In the UK, that equivalent proposal, I'm still waiting to see it, let alone being able to read it. So I think what this tells me is that, on the one hand, we need to stick together. We need to do this internationally. I mean, the idea of national streaming and national solutions, I'm not a great fan. I don't think that works for anyone. 200 different solutions globally with a global phenomenon, I don't believe in that. The other thing I'm afraid I don't believe in is this idea that contracts will solve all of our problems. Contracts are a great tool, don't misunderstand me, but contracts work rather well if you have, relatively speaking, equal bargaining power. Now, isn't that the one thing that we don't have in this kind of area? So I think that's a major problem. We've proven that again in the UK. We've tried very hard. Other countries have been maybe a bit more successful, but leaving it all to contracts doesn't work. Now, the other point I would like to make, Christophe, if you give me a second, is that I like all this idea, like, why do we need another remuneration right? Well, as an academic, I see a massive difference. On the one hand, you have copyright, And then you have related rights. In terms of copyright and related rights, we start with the same position. What we effectively get are negative rights. You can stop other people from copying your work, from communicating it to the public. You stop people from recording your music without your permission. Turning that into a positive right that you can license, that you can contract on out, that you can monetize, that takes something more. If you have a right of communication to the public, reproduction right, it's easier to see how that can be achieved. What we have, for example, in the WPPT, is not that. We just have the negative portion. In 1996, this was great news because we had all the piracy, and you could stop that. What we need is a tool to be able to monetize that, a stronger position to negotiate in. To my taste, that's a form of remuneration right. That's effectively what you need to, as it were, equal out, in part, the bargaining position and do something. Now, some people will say, you're dreaming because the pie will not get bigger. I don't think that's the problem. The problem is the distribution of the pie. The distribution that works in a different way when you're an author or when you're a performer, because of the inequalities in the legal framework. If we can manage to sort that out, be it via the Belgian-Spanish solution or any other, I think we'll make a major step forward. If anything, coming back to your initial question, the current UK experience has shown that leaving it to full contractual negotiations and an absolute failure by the legislators to intervene and to help is not the solution, because we have nice reports, but nothing's happening. And that's not the way forward. The industry goes forward, the technology goes forward. If the legislator doesn't move, we're getting nowhere. The distance between us and reality is getting bigger.
So basically, legislators should take up their responsibility, but even when you have a legal basis, it's always a very hard uphill battle to get tariffs to go out and negotiate. Spanish example has been mentioned on a couple of occasions. They got the legal basis in 2006, and Paloma, correct me if I'm wrong, but it was only in 2019 that they started to collect and then later on distribute. So there's a lot of deterring mechanisms, a lot of breaks in the system, going from the legislative process, then when you have a legal basis, it is being challenged. So there's a lot of difficulty there from predominantly people who tell us that they put the artist at the center of their activities, not being cynical here. I'm going to go to France now, because France has a very specific solution that they have developed. Et par conséquent, je vais changer vers le français, donc si vous avez besoin de la traduction, n'hésitez pas. Philippe, la France occupe une position assez particulière dans ce paysage du droit voisin ou du droit d'auteur, dans ce sens que vous avez conclu une convention collective en 2022, si je ne me trompe pas, avec les producteurs phonogrammes. Une convention qui inclut également quelque chose qui m'a toujours surpris un tout petit peu, mais qui est propre au système français, c'est la notion de forfait. Donc, si tu veux bien nous expliquer brièvement en quoi consiste la convention collective, on va essayer brièvement, en quoi consiste la convention collective et qu'est-ce que cette notion de forfait représente dans le système français, à défaut d'une notion plus claire. Je t'en prie.
Merci Christophe. Je vais essayer de présenter les choses, mais je veux dire en premier que de nombreux problèmes qui ont été présentés ce matin, qui représentent je dirais, différentes strates d'inégalité dans la répartition des revenus du streaming, ne sont pas réglés par l'accord qu'on a. On a un accord entre les artistes-interprètes et les producteurs. Le fait que, tout le monde a bien entendu ce matin, le fait que ce soit seulement quelques enregistrements qui captent toute la valeur, évidemment, l'accord qu'on a signé ne vient pas régler tous les problèmes à ce niveau-là. Et je me garderais bien d'imaginer que l'accord qu'on a signé, puisque c'est le titre du panel de cet après-midi, constituerait une solution pour tous les problèmes que nous avons évoqués ce matin. En France, nous avons l'avantage d'avoir les artistes du spectacle un statut de salarié, ce qui fait que, en tant que syndicat, eh bien, nous pouvons représenter les artistes et signer des conventions collectives. C'est quelque chose qui est très précieux. Alors, c'est une autre réserve que je veux dire en premier. Là, l'accord que nous avons signé n'est pas le premier. Il y a eu un excellent accord qui a été signé en 1969. En 1969, tous les studios travaillaient 7 jours par semaine. L'industrie française sortait des titres chaque semaine. Il y avait de nombreux musiciens, parfois des dizaines de musiciens sur chaque titre. Et en 1969, il y a eu une grève pour obtenir un bon accord. Et il y a eu un bon accord. Et en 2022, pour le streaming, nous avons négocié avec les producteurs pour le streaming, mais la situation n'est plus la même. Il y a beaucoup moins de musiciens dans les studios, nous n'avons pas le rapport de force, et ma foi, ce ne sont plus, je dirais, les conditions de négociation d'un certain âge d'or qui sont celles d'aujourd'hui. Alors, me direz-vous, mais qu'avez-vous donc négocié en 2022 ? C'est un accord qui s'appelle garantie de rémunération minimale, donc sur le streaming. Et cet accord, dont je ne donnerai pas tous les détails ici, principalement, il se divise en 2 parties. Une partie pour les artistes principaux et une partie pour les artistes non principaux ou musiciens de session. Je vais commencer par cela, les musiciens de session. Donc, l'accord prévoit un forfait, une rémunération fixe qui est payée au moment de l'enregistrement, et si le titre, c'est pas par album, c'est par titre, si l'enregistrement trouve du succès, eh bien, il est prévu qu'il y ait d'autres rémunérations qui puissent être perçues par palier. Quand le titre atteint 7,5 millions de streams, il y a une rémunération complémentaire. Quand le titre atteint 15 millions de streams, il y a une rémunération complémentaire. Quand le titre atteint 30 millions, 50 millions, il y a des rémunérations complémentaires qui ne sont que de quelques dizaines d'euros à chaque fois. Mais si je puis dire, il est possible de cumuler. Voilà ce que nous avons signé. Comme tu le disais, Christophe, pour nous, c'était très important qu'il y ait une partie fixe dans la rémunération du streaming. Et d'ailleurs, je vais y venir, il y a aussi une partie fixe pour les artistes principaux. Parce que il y a un certain niveau de production en France. Il y a tout de même des centaines d'albums qui sont produits chaque année. Et sur les centaines d'albums qui sont produits chaque année, il y en a très peu qui trouvent leur économie. Il y en a très peu qui sont beaucoup streamés. Et pour nous, la valeur c'est quelque chose de fondamental pour nous. La valeur d'une plateforme de streaming, la valeur d'un abonnement, c'est que les gens s'abonnent pour avoir accès à l'intégralité des titres. Donc la valeur, c'est qu'il y a tout, et la valeur, ce n'est pas que ce qui est le plus écouté. Et c'était dans notre négociation un des points sur lequel on a réussi à plutôt ne pas lâcher.
Ce qui veut dire par conséquent, le seul fait d'avoir chargé un morceau sur une plateforme de streaming justifie un paiement, même si ce morceau n'a jamais été écouté, n'a jamais fait partie de streams.
Parce que nous estimons que les consommateurs payent un abonnement pour avoir accès à l'intégralité du catalogue. Et je crois que c'est vrai. Je crois que les gens s'abonnent parce qu'il y a tout dessus. Et qu'ils ne paieraient pas ce prix-là juste pour écouter les 500 titres qui sont les plus écoutés. Et puis, il y a donc un versant pour les artistes principaux qui se décline aussi avec, d'une part, un forfait et, d'autre part, des rémunérations proportionnelles. Alors, le forfait est de 1 000 € par album. Voilà, ce qui est une somme qui est faible.
Et c'est payé par les producteurs de
C'est payé par le producteur de l'enregistrement. C'est une somme qui est faible, mais il y a aussi en France tout un système de subventions, d'aide publique pour aider la production et la diversité de la production. Et ce que l'on sait, c'est que la plupart des enregistrements qui y compris sont aidés, ne font pas 1 000 € de recettes sur les plateformes. C'est-à-dire que la plupart des enregistrements ne font pas 1 000 € sur la plateforme de streaming, et donc que finalement, il était difficile d'exiger des producteurs d'avoir plus que ça. Alors,
et ça vaut pour tous les artistes et également les non-features?
Non, ça c'est pour les principaux. Et puis, je voulais dire, voilà. Et donc évidemment, pour les artistes principaux, il y a aussi une rémunération proportionnelle. Alors celle-ci peut varier selon que le producteur est aussi distributeur, pas distributeur. Enfin, c'est un accord, c'est compliqué. Mais disons que ça va de 11% jusqu'à 28% si le producteur est en licence. Voilà. Alors, évidemment, le chiffre est faible aussi, mais je dirais, nous n'avons pas eu mieux. Alors, vous avez entendu ce matin quelque chose qui est paru dans un rapport de l'IFPI il y a un mois. Vous avez entendu ce matin Laurie Richard dire que selon l'IFPI, 35% des sommes que perçoivent les labels de la part des plateformes de streaming vont aux artistes. Et cette somme, ce chiffre a été publié dans le rapport de l'IFPI il y a un mois. Le rapport de l'IFPI pour l'Europe. 35%. Alors, vous allez me dire, vous les Français, vous êtes des rigolos, avec 11%. Vous avez négocié 11%, alors que l'IFPI affirme qu'il verse 35%. La première chose, c'est quand on a vu ce chiffre-là, on s'est adressé tout de suite aux membres français de l'IFPI. On leur a dit, ça fait des années qu'on vous demande, quel est le pourcentage que vous versez aux artistes en vrai. Ça fait des années que vous nous refusez cette statistique. Et là, le membre français de l'IFPI nous a dit, premièrement, nous ne savions pas que l'IFPI avait publié ce chiffre. Deuxièmement, l'IFPI ne nous a rien demandé sur les droits que nous versons en France pour établir la statistique européenne. Et troisièmement, ce chiffre doit être faux puisqu'il accumule différentes données qui sont différentes les unes des autres. Voilà. Et je parle de ça pour dire à quel point il est difficile de négocier avec l'opacité dans laquelle on se trouve, c'est-à-dire que au cours de la négociation sur la garantie de rémunération minimale, la difficulté principale qui revenait toutes les 30 minutes dans la négociation, c'était secret des affaires, secret des affaires, secret des affaires. C'est-à-dire que je viens ici vous présenter cet accord, nous l'avons signé, nous estimons qu'il est meilleur pour les artistes d'avoir signé cet accord que de les avoir laissés sans accord. Mais malgré tout, nous estimons que les conditions de la négociation sont très mauvaises et nous estimons qu'il y a, enfin je pense que c'est beaucoup ressorti dans les débats de ce matin, il y a vraiment beaucoup de problèmes à régler en amont de la négociation des droits des artistes, et on peut pas entendre des vérités tellement opposées les unes aux autres comme on les a entendues ce matin, et ensuite prétendre négocier un accord qui serait juste.
D'accord, mais je partage tout à fait votre avis. Lorsque j'ai lu ces statistiques à la page 6 du rapport de l'IFPI, je me demandais, mais d'où est-ce que ça vient? Ce sont des statistiques, ce sont des montants qui sont cités, dont personne n'a pu m'expliquer jusqu'à l'heure actuelle d'où est-ce que ça vient. Et donc, il y a un manque de transparence dans le modèle qui est organisé surtout entre les plateformes de streaming et les producteurs de phonogrammes. Je me souviens, il y a une dizaine d'années, il y a eu une fuite, un contrat entre Sony, je crois, et Spotify qui a été publié sur la toile, sur l'Internet. Et c'était à ce moment-là la première fois qu'on a su prendre connaissance des conditions qui sont liées à l'entrée sur ce marché-là, ce qui est également très difficile pour les producteurs indépendants. Pas mal de mes membres sont non seulement musiciens, auteurs, compositeurs, artistes, interprètes, mais également producteurs. Et surtout pour les producteurs indépendants, il y a pas mal de seuils qui sont créés afin de pouvoir accéder à ce marché-là. I'm going to go back to English right now because this also sheds some light on the role of musicians' unions, how they can weigh on, for instance, the contractual process. Again, I've been in this business for 15 years. When I started out, we had on the table a draft contract for session musicians negotiated between us and the IFPI branch in Belgium. Is still not being implemented. Do you feel that there is a necessity for, and then I'm looking at both Philippe and Tino, is there a necessity for musicians' unions to start this dialogue to obtain standard contractual clauses for musicians, for session musicians, some kind of a minimum remuneration? Because if we're going to wait for the legislature, we've been waiting on them for quite a while. Do you think there is actually an opportunity there?
I believe there is. But we got to start talking to each other, because until that communication happens at a level where we're all seated at the table and we're acting as one, then we'll get something done. The problem that we have, and we always run into this, right? We all have our own interests. We all have our own standards that we're looking to enforce. And so there has to be a give and take when we come together if we're going to show a unified front to those companies that are taking advantage and exploiting our members. I think that's the first step. But it is a three-pronged approach, right? It's a collective bargaining process. You got to be strong at the table. You got to have unity within the group that you're bargaining for. There's also the legislative activity that you have to embark on, which takes resources. You've got to be at the seat of your government. You've got to be at those meetings. You've got to participate. You've got to let them know that, especially with the electeds, at least in the United States, they care about where they get their votes. So that's really important. And of course, there's also, the problem that we have with the continued erosion of workers' rights, basic workers' rights. In the United States, it's called the National Labor Relations Board, which the current president is trying to dismantle. which would make things like implementing an agreement that was bargained and signed enforced. So yeah, I think there is a way we can sit at the table. The minimum, you know, the minimum standard for agreements is definitely something that the AFM has always been very interested in.
Philippe, do you want to contribute to the way that unions can or should be working on behalf of their members?
Sur le rôle des syndicats et l'activisme, bon, là, nous, on a redemandé la négociation de l'accord dont j'ai parlé pour les musiciens non principaux, principalement parce qu'on a vu les chiffres, on a vu les résultats des majors, et on a dit l'économie du secteur n'est plus ce qu'elle était il y a encore 3 ans. Donc nous voulons avoir plus, on va voir. Et je pense qu'il y a une autre bataille qui est à mener par les syndicats, c'est la bataille de la transparence. Parce que, notamment, pour la situation en Europe, la directive de 2019 peut normalement être un levier puissant pour que les artistes aient accès aux informations, pas seulement aux informations sur ce que touche leur label, mais les artistes, en tout cas pour l'Europe, ont le droit de savoir jusqu'au dernier sous-cessionnaire, c'est-à-dire jusqu'à la plateforme, combien d'argent est généré par leurs enregistrements. Et je pense que cette bataille de la transparence est une bataille que nous devons tous mener aussi parce que il y a trop de choses qui sont encore cachées aujourd'hui. Et je pense que un des moyens de gagner serait d'établir plus clairement les choses sur qui s'enrichit, à quel endroit, avec notre travail.
I have a follow-up question for all the panelists here. We've already touched upon it, but in some negative way this morning during the first panel, the role of collective management organizations. The representative of IFPI seemed to suggest that there's actually no role whatsoever for collective management organizations. I see a lot of my colleagues here in the room because they're just the middleman. They're just a hindrance to what could be a very fluid and a very beneficial process, both for the users of the repertoire, the record producers, and the performing artists. We're not unions, we're a collective management organization. We have a lot in common, but I still believe that in terms of acting together in order to obtain a proper level of protection for our members, that this is something certainly to be considered. And we've been actually quite successful in Belgium. The fact that we were able to obtain a legislative framework that is very beneficial was because we acted together. It's an open question to all panelists. How do you see the collaboration between unions and CMOs, for instance, between AFM and Sound Exchange, or between the CGT and Spiridam Adami? They seem like natural allies. So do you believe that there is room to develop more this relationship and to act together?
Well, speaking for Sound Exchange, I'm on the board at Sound Exchange. I'm also the co-chair of the AFM SAG-AFTRA Intellectual Rights, Property Rights Distribution Fund, and they're the ones that distribute to the side musicians and the background singers. It's a little different for us because there's always been a strong collaboration. Not so much with the artists. So Sound Exchange is made up in 2 groups. You have your artist representatives, which the unions sit on, and then you have the label representatives on the other side. I mean, there are conflicts when we go there, but generally speaking, we work very collaboratively together. Unfortunately, that's not part of the collective bargaining process. For the IPRDF, it's a completely different set of circumstances because it is a CMO that is made up of SAG-AFTRA and the AFM. So we're actually one and the same in that case. So, we bend over backwards to do things like defend mandates and things like that when we see someone not getting the money that they deserve. Like you said, show me the money.
Sur la question de la collaboration entre les syndicats et les organismes de gestion collective, en France, la situation a été difficile pendant de nombreuses années. Pour le dire très rapidement, les syndicats signaient des accords et les sociétés de gestion collective disaient les accords sont trop faibles, vous bradez les droits. Et puis les organismes de gestion collective disaient il faudrait une autre loi, il faudrait un autre système. Et nous, on disait vous voudriez un autre système, mais vous ne le mettez pas en place. Bon, heureusement, on est sorti de ce dialogue absolument inutile. Nous travaillons maintenant, y compris d'un point de vue pratique. Il y a une fois par mois une réunion de coordination des syndicats d'artistes et des organismes de gestion collective en France. Nous travaillons en commun les sujets streaming, les sujets IA, tous les sujets d'actualité, et je dirais, ensemble, nous faisons feu de tout bois. Évidemment, les syndicats restent parfaitement souverains et les décisions qui concernent les syndicats sont prises à l'intérieur des syndicats, et puis les organismes de gestion collective restent souverains aussi, ils ont leur propre gouvernance et ce sont leurs administrateurs qui décident, mais on se parle, on travaille, on met les dossiers sur la table le plus simplement possible, et puis on essaye de mobiliser, malgré tout, je le dis, des fois par rapport à l'industrie, par rapport à ce qu'on a en face, même en se mettant tous ensemble, les syndicats et les organismes de gestion collective, nous n'avons qu'une influence qui est trop faible. Je ne sais pas si, par exemple, vous avez vu le récent sommet sur l'IA qui s'est tenu à Paris en début d'année. Voilà, la question des artistes-interprètes et de leurs droits a été à peine évoquée parce que les représentants de l'industrie, parce que le pouvoir politique, trop proche des représentants de l'industrie, décidait de passer par-dessus notre tête.
Well, one of the reasons why I asked this is because we've noticed, especially in Europe, where you have a number of what we call joint CMOs, meaning both record producers and performing artists in one and the same company, one and the same CMO. We have noticed that on several occasions and on policy issues where we don't see eye to eye, that these CMOs tend to take a more neutral stance. And even there was one CMO where the record producers chapter prohibited the performing artists chapter of distributing a survey about the rights of performing artists on streaming. And this will sound also familiar to Julie in South Korea. Collective management has been faced since ages and still being faced with a lot of prejudice about us not being transparent, not being objective, not being efficient in the processes. So I was wondering if this same, let's say, culture or approach of what is a collective management organization, the same level of prejudice equally exists in your country. Julie, could you develop a little bit on that?
Yeah, sure. I believe that at least in the case of performers, such prejudice cannot apply. Individual performers, as you know, have very limited bargaining power when dealing with online service providers or record producers. And in reality, it's almost impossible to negotiate individual licenses and make royalty payments to each performer one by one. So that's exactly why the collective management system is most essential in this area. Now, having said that, let me briefly share one of the unique features of the Korean collective management system. In Korea, there are certain institutional safeguards to address potential side effects that may arise from FKMPs exercising the assigned performers' rights, such as hindering or slowing down the distribution of sound recordings. Under these safeguards, FKMP cannot refuse to grant a license, and FKMP must grant licenses even for new services that are not yet covered by the regulations. These safeguards are according to FKMP's terms and conditions for use agreement, which must be approved by the Korean Ministry of Culture, Sports and Tourism. As a result, the system operates in a way similar to a remuneration scheme, ensuring that record producers who invest substantial amounts of money in recording and distribution also have their legitimate business interests protected. From the perspective of OSPs as well, this creates a highly efficient and predictable system since they can always obtain the necessary license from FKMP. So in practice, it functions with high institutional effectiveness and satisfaction for all parties involved. It's also important to note that in Korea, performers are not legally obliged to exercise their rights only through the CMO. If a performer prefers, they can join another agency, manage their rights independently, or even delegate their rights to a record producer. So in that sense, in Korea, there's no such bias or monopoly in practice. So to sum up, I believe that the collective management system plays a crucial role in enhancing social recognition of performers' rights, especially for non-featured artists who generally have shorter active careers than other rights holders, and in fostering a sustainable music ecosystem. Of course, every country has its own unique circumstances, but I truly believe that the Korean experience offers meaningful inspiration for how music performers' rights can evolve in the digital era.
Thank you, and we'll certainly take our time to study the Korean example. It's really fascinating. There's one last topic that I would like to discuss with the members of the panel, which has not been touched upon until now, and that is cultural diversity. I've quoted already at the beginning of my keynote speech the fact that almost 70, and it's closer to 80% of all global revenue on recorded music is generated via streaming, which makes that streaming platforms, all of them combined, have a dominant impact on the way that we access and enjoy music. And what you see is that in their business model, they are pushing a number of playlists that they curate. Now, I was sitting in on not on a panel, but in a meeting with a number of Belgian music professionals, and also the local CEOs of the majors were there. And there was one CEO of one of the majors who just bluntly said during the meeting, well, my bosses, London, New York, Tokyo, whatever, are not really that much interested in the local repertoire. The only thing they're interested in is the statistics that the big stars, Taylor Swift, Ed Sheeran, etc., are generating on the Belgian territory, on your national territory. And local repertoire, not so interesting for us, not so really much invested in that. And that's quite literally, we've made some statistics that show that in 2016, our national charts in their top 100 albums contained 64 albums produced in Belgium. When we did the same exercise after the charts started to include streaming numbers, we saw that figure drop in 2024 to 16 albums. So there's a lot less visibility, a lot less ways for local artists to get on not only an international scene, but also on a national level to get this exposure. Contrary to what record producers and streaming platforms are saying, we've created a level playing field and anyone can participate in this music market. We found out that was not the case. So what we started doing on a Belgian level, and it's quite peculiar, we created our own charts, which is a combination of airplay and streaming numbers. And we've been broadcasting that together with a number of media partners. And you see a lot of the local repertoire all of a sudden growing slightly in importance. It's very new to us, and we've been starting that up since September. But it is one of the ways in which we try to cherish and nurture the cultural diversity. So again, you have this onslaught of the international repertoire, predominantly an American, perhaps a UK repertoire, but this might also be one of the ways that we try to safeguard cultural diversity. And I was wondering whether you had any experiences with that in your respective countries, that you have artists complaining about a lack of visibility, a lack of being able to promote their recordings and to participate in the cultural life and to go beyond the borders of the national territory. Anyone? Some insights on cultural diversity?
I hate to be the one that's always chiming in here. I apologize. Well, I can tell you right now that, I think our Canadian members, the AFM Canada, enjoy stronger legislative control over cultural diversity. But the market in North America itself is pretty diverse. There's a lot going on there. And to be honest with you, a lot of the Sound Exchange probably collects more money from terrestrial airplay than from the streaming services. And that, to me, is a cultural indicator. What people are listening to, why a radio station is putting together a particular playlist, as an example. And I think that's where the local communities are stronger. They're listening to their music. It's a shame what's happened. I mean, there was a time when a local band could walk into a radio station and say, I want you to hear something. And if the DJ liked it, they got to press a single or something, Things have changed considerably there. And I have to tell you, the business model for streaming particularly is not working. It's not working for musicians.
Well, I think what we also shouldn't forget is that what we've seen in a number of European countries, at least, is that the market for the local music, I don't like the term because it sounds like it's not as good as, but that market was primarily a market where the consumer was a little bit older. The consumer was maybe not as internet savvy as the current generation is. So I think what you see with the arrival of the internet and the availability of these things is that the young generation is exposed to that, takes that on board, and it's when the performing artists and the musicians take up that same technology, fit in with that business model, that I think you see it pick up. We see, to come back to our joint home country, there are a number of artists who do really well in the local language with a local product, a product they put in the market as local, on the basis that they play the game. They play the game as the business is run now. So I think that's part of the solution. At risk of being controversial, there is, of course, another example. In a number of relatively poor, to say extremely poor, Asian countries, what I've seen is a model where, in order to generate income, in order to get the gigs out, artists use platforms like YouTube and basically release their own music for free, get the success and then the status from there, and then do it as a performance. I'm not saying that's a model, but I think you also need, if you want diversity, you need to find the business model that works. I think in many markets, that's now the modern platform, internet-based technology, where you have to put yourself in the market as an artist on that platform. I think that works. What also works is maybe not do it for free, but I see a number of countries where governments subsidize, where governments promote actively by positive measures local content. things work better than in countries where that isn't happening. So I think that's another model. It's another model that also works quite well in the audiovisual sector, where you know, if you have the local content, if you provide the local initiative, then you can rely on a certain form of funding. I don't see any reason why that couldn't work to promote diversity and local content in the music market, in the performing market.
Well, we're actually looking into that idea because, as you mentioned, in Belgium, but also in a number of other countries, in the audiovisual industry, the legislation, you have an obligation for streaming platforms to invest in local content, and it's about 4 to 5%. This is being challenged before the courts and tribunals. So we're considering that as a possible solution to oblige streaming platforms, YouTube, etc., UGC platforms, to invest in local content, but in a proportionate manner, of course. But I'm pretty sure if we introduce that, it'll be challenged as well before the courts and tribunals.
Christophe, everything will be challenged. We teach our students that they have to make money at the end of the road, so that's the way it is. And as you said earlier, CMOs and others historically have a reputation. And I think but coming back to, if you allow me for a second, coming back to that point, I think it's extremely important. We talk about transparency in a lot of these things. Well, I think that's where CMOs have a role to play. You know, if I individually, don't ask me to perform music, unless you want to repair the fire alarm, that would work. Everyone out in 5 seconds if I start. But if I take my work as an academic author, if people make photocopies of that, the idea that I'm going to find out the information, who's making the copies and whether I'm entitled to something, forget about it. I think in this kind of business, especially for local artists or starting artists, there is an important role for a CMO to provide that element of information, that element of transparency, collecting that information, passing that on. That's an important role. And maybe trade unions have a different role. Leave that to the other partners. It strikes me that's a model that can work. There we can all play our role. But that was your previous question, sorry.
Thank you. I see that we have still 2 minutes left, so any concluding remarks? I'm going to start with Marcos in Brazil, if he's still with us. Any concluding remarks from your part?
Yes, let me talk about this point of cultural diversity. En Brasil, nosotros tenemos una situación diferente, porque el contenido local es muy apreciado en música, y por razones históricas, culturales, tal vez por la influencia de nosotros hablarmos portugués y sermos uno de los únicos países con esa lengua, la presencia del contenido nacional en todos los medios de explotación de música, desde televisión, de radio y en streaming, hay una presencia grande del contenido nacional, y tal vez el problema que tengamos sea la prevalencia de un género musical como el sertanejo, que es un tipo de un género musical brasileño, delante de los otros géneros. Ahora, me gustaría llamar la atención que sobre ese punto hay una discusión en curso en UNESCO que creo que todos deberían estar cientes. Hay una discusión para la creación de un protocolo adicional a la Convención sobre la Protección y Promoción de la Diversidad de las Expresiones Culturales, para incluir las disposiciones de esa convención, o mejor, el entorno digital en las discusiones las disposiciones de la convención. O sea, es un protocolo adicional en la Convención de Diversidad para el entorno digital. Nosotros estamos defendiendo esa propuesta, hay otros países que también defienden y sería interesante una aprobación de un protocolo porque entonces los países tendrían la libertad de hacer una política pública, por ejemplo, obligando las plataformas de streaming, como Christophe acaba de decir, a sugerir y disponibilizar el contenido local en cada jurisdicción. Gracias a eso y más una vez, gracias por la invitación para ese panel.
Thank you for your contributions, Marcos. I'm going to go over to Julie now, if you have any concluding remarks.
So FKMP being the music performers CMO exercising their exclusive rights, I think it's a quite rare combination across the globe. So please, Christophe and any others, to study Korean cases, and anytime come to Korea, let's help you out each other. Thanks. Thank you for inviting me.
Thank you for your contribution, very valuable. I'm turning to the persons who are physically present with us now. Tino, any final concluding remarks?
No, not really, not at this point, but I do want to thank you for your work. You did a great job moderating. I appreciated the questions, and I'm glad we're having a conversation. I'm glad we're talking about this. Let's move forward.
La France.
Merci beaucoup, c'était très intéressant. J'espère que la prochaine fois, il y aura plus de femmes dans le panel, parce qu'autrement, je vais avoir un problème avec les personnes de mon syndicat quand je vais rentrer.
I understand that diversity on all levels and inclusion is a very important one. I completely agree. Some concluding remarks from you, Paul.
Well, nothing extra really, just to say it was really enjoyable, and let's hope that the audience has quite a number of questions now. So I think that's what we do next, no?
That'll have to wait. After the coffee break, there will be ample opportunity to ask questions. Thank you for your attention. Thank you to all the panelists, really very helpful. And we'll see each other after the coffee break. Thank you.